지금부터 국제특허법원 컨퍼런스의 첫 번째 세션을 시작하겠습니다. 이번 세션은 IP 소송의 최근 동향이라는
We will now begin session 1 of the International IP Court Conference. We will have Song Yeol-seo as the moderator. He's the chief presiding judge of the Patent Court of Korea. Please welcome him with a big round of applause.
예, 반갑습니다. 안녕하십니까? 오늘 제1세션의 사회를
So greetings. I'm Song Yeol-seo. I will be moderating session 1.
제1세션은 해외 주요 국가와 우리나라의
So in the first session, we will be looking at the recent trends in global IP litigations in Korea as well as other major countries around the world. So this is the first session of the conference. Starting from session 2, we'll be looking into specific topics. But before jumping into this discussion, we'll be looking at the major changes in the IP status around the world as well as looking at the trends of major court decisions. Not only United States, but also Switzerland, Turkey, India. We'll be looking at recent developments in these countries, and so we'll be able to broaden our horizon internationally related to IP litigations. So we ask for your understanding. So I'm a very handsome-looking man, but because of the quarantine measures for the COVID-19, I would have to wear a face mask. So I do regret not being able to show my very handsome face to all of you. So let me introduce today's panelists. So those of you taking part via online, please welcome everyone with a big round of applause in your hearts. So on my left is Taek-soo Chung, the High Court Judge of the Patent Court of Korea. So he has already said his hello, so I will omit that. And from the Law School of UC Berkeley, we have Professor Jeremy Fogel. And also we have Judge Elian Insef from Turkey, and also we have Pasifa Singh, the presiding judge of Delhi High Court, and also President Mark Schweitzer from the Swiss Federal Patent Court, who will be joining us through a pre-recorded video. We'll be skipping the detailed bio because of the time constraint, but I can say this, that all of our panelists have built up a brilliant career in the IP litigation area in their respective countries. So please refer to their detailed bio in the booklet that has been handed out to you. And so there is a reason why these 5 panelists or 5 countries have been selected for the first session as panelists. Do you know why? It's actually related to one of the words that are included in the theme of this conference. I'll give you the answer at the very end of today's session. So let us jump into session 1. So in session 1, we will be dealing with broadly 3 topics. First is the trends and changes in major IP statutes in the countries, or the respective countries for the last 3 years. And also the second question is the trends of major IP cases for the last 3 years. And the third question is current legal issues or those expected to be hotly debated in IP. So the written answers of our panelists are all included in the booklet that has been handed out to you. So in this session, with regard to these 3 questions, among the written answers that you have already provided, you can highlight those parts that you believe are really pertinent, most important for this questions. First, we will invite our very first panelist, and it's Professor Jeremy Fogel from the United States. Professor Fogel, are you online? Greetings. Hello.
Professor
Fogel, can you hear us?
예, 잠깐. 기술적인 문제가 교수님 아마 교수님
I think we
소리가
have some technical problem here. There's a really huge echo from your part.
자, 교수님 반갑습니다. 혹시 제 목소리
Professor
잘
Fogel,
들리시나요?
can you hear me well?
저희들이 아마 소리가 들리지 않는데 스태프분들
We can't hear Professor Fogel. We do have technical staff with us, so please check the issue with the audio.
그럴까요? 예, 예. 포겔 교수님 아마 기술적인
Professor
문제가
Fogel, because
있는 것
of
같습니다.
some
그래서
technical
저희들이
glitches,
기술적인 문제를 조금
we need,
해결할 때
while we are resolving this issue, please wait a while. So we will move on to the next panelist
예, 하겠습니다. 예,
and take
좋습니다.
care of this issue in between.
Okay, thank you.
네, 알겠습니다.
지금도 되는 것 같네.
Well, I think it's working now.
혹시 지금
Okay, is this good now?
yes. 예.
Yes,
예,
yes.
반갑습니다. 지금 많이 당황하셨죠? 예.
I'm sure you must have been quite taken aback by this
원래
problem.
I'm fine. I'm happy to be with you. And I just wanted to say for the first 15 seconds, I'm sorry I'm not with you in person. I was in Korea right before the pandemic started. I had an absolutely wonderful time. I was treated with such warm and wonderful hospitality, and I look forward to being with you again sometime when it's safe for that to happen. But I'm so grateful for the relationship that our institute at Berkeley has developed with the Korean judiciary, and thank you for inviting me. My 3 points actually all relate to the same general point, which is who is making the decisions in patent cases. As you know, the United States, along with the UK and Australia and India and a few other countries, is a common law jurisdiction. Most of the world is a civil law jurisdiction. And in our system, it's an adversarial system. So instead of the judge being the primary investigator of the facts, that is done through presentations by the parties. And the parties, because they have an interest in the outcome, don't always present the facts in the most objective way. So you get, in the same case, you might have one party painting one picture of reality and the other party painting another. And this extends to technical experts as well as other witnesses. The judges, on the other hand, in our system are generalists. They are not trained as technical experts. Very, very few judges in the US federal courts have a technical background. A few more are experienced in hearing patent cases, but even so, you are limited by your understanding of the technology. I was a judge for 20 years in the federal court in San Jose. I heard well over 150 patent cases, and there were cases I simply didn't understand the technology, and I needed the help of experts to do that. And that creates an incentive for the parties to find experts who will present the facts in the light most favorable to them. So part of the solution to that problem in the US, and it's not a case law solution, or it was a statutory change that was made several years ago, was to create a stronger administrative review process for patents. So after a patent is issued, the patents can be reviewed by something called the Patent and Trademark Appeals Board, which is actually a very robust administrative body, and they have the technical expertise to review patents for obviousness, for other forms of invalidity, and that actually has been helpful in reducing the number of patents on the market that lack technical merit. And the people making those decisions are trained, as I said, in the technology. So that's been a major shift. I will say in a few minutes how that I think is somewhat in peril because of directions that our Supreme Court is taking. But I think that's probably the biggest change in the way IP cases are litigated in the US in the last 3 years, which is the increasing reliance on administrative proceedings. The second point is that our courts continue to be struggling with identifying what is patentable subject matter. What is a natural phenomenon and what is something that can be patented. And our Supreme Court has tried a number of times to define it. I think it's fair to say they haven't really succeeded in coming up with a definition that works all the time. Our Federal Circuit, which is the intermediate court, the appellate court that handles all patent cases by statute, they issued an opinion on patentable subject matter that had 11 different opinions. The judges came up with 11 different opinions as to how the case ought to be decided. So this continues to be a real struggle for us. And then the other one, which relates to who the decision maker is a dispute over where cases should be tried. This was in our system, it's called venue. It's the location of where cases are tried. And as you know, the U.S. is a big country physically. And the parties try to manipulate where cases are heard and by which judge. And there was a trend for a number of years that plaintiffs, people who were asserting infringement of patents, wanted their cases heard in Texas because the juries, and it's another way that we're very different. We have jury trials in patent cases. Juries in Texas were giving big verdicts for plaintiffs. And so people were trying to manipulate the venue rules so that they could have their cases heard there. And that, of course, has come under fire, and our higher courts have tried to attack that process. The Supreme Court issued a decision, and the Federal Circuit has issued some as well. So those are the issues that are being litigated frequently now. The one that I wanted to spend the last few minutes of my time talking about, though, is the role of technical experts. Because when you have a generalist court, like we do here, I never got a degree in science. I heard all those patent cases. I have no technical training at all, other than what I learned on the job. That the role of technical experts in helping courts decide cases is very problematic because, as I said, the parties are incentivized to choose experts who favor their point of view. The court has to decide which expert to believe in determining the scope of the claims. The jury has to decide what expert to believe when they decide the case, and they have no scientific grounding that enables them to do that. And so this has been a continuing problem. Some judges have even institutionalized it where they use the same expert over and over again so that at least they have a regular court-appointed expert who gives them an opinion. But I think that the real challenge in a common law system where the judges are not technically trained is figuring out how to get reliable expert testimony. And that continues to be a big issue here. Administrative proceedings before the Patent and Trademark Appeals Board are a partial solution to that problem because those people do have expertise, and so they can give guidance as to the proper interpretation of patents and whether patents are valid or not. But as I was saying earlier, the Supreme Court has perhaps a majority at this point who, as a matter of philosophy, do not want to give administrative agencies a great deal of plenary power, and that may result in the role of PTAB and other administrative agencies being limited as a result of constitutional interpretations by our Supreme Court. And I think that's something that we'll need to watch very carefully going forward. I did want to comment on Judge Schweitzer's comment and question about people contesting invalidity later on in the proceeding. Is there ever a time limit for that? Can people keep changing their claims as things go forward when it appears that one particular set of claims may be invalid? And I think as long as the patent hasn't been cleared by the Patent and Trademark Office, as long as the administrative process is still ongoing, it seems to me people routinely change their claims in order to get them issued. And that's been true in patent prosecution all over the world. I think the question that Judge Schweitzer is asking is, once you get in litigation, can a party change the interpretation of its claims? Can they say, well, my patent doesn't really mean what I said it means something else? I think that's very problematic as a matter of fairness to the parties. I think it's very hard from an economic standpoint. It's very hard to rely upon patent rights if a party can keep changing what they mean and what the proper interpretation of those rights is. So I think that's a very dangerous road to go down. I don't think it would be possible in the U.S. I went back and actually looked at an old case of mine that I decided probably 15 years ago, and that issue came up. Looked like the patent was going to be held invalid. It actually did end up being held invalid, and the claimant tried to come up with a new, we found a new benefit of our patent that we didn't claim, but it actually is a really good benefit, so we shouldn't have our patent invalidated for obviousness. I said, you can't do that. That's not, it's not fair to anybody, and certainly not people who are your competitors who might want to practice the same type of invention. And that was upheld by the Federal Circuit. So I don't think there's a lot of openness here to changing the interpretation of patent late in the day. So those are my comments, and I look forward to hearing from my colleagues from other countries. And again, thank you for inviting me to participate.
예, 포겔 교수님 감사합니다. 예, 몇 년간 우리 컨퍼런스에서 자주 언급됐던 특허 대상 적격과 특허 소송의 법정지 문제, 그리고 정정에 관련된 여러 가지 깊은 경험과 식견을 보여주셨습니다. 바쁜 업무 가운데서도 이렇게 참석해 주신 포겔 교수님께 다시 한번 감사드립니다. 그리고 아마 교수님께서 우리 보내주신 아마 프로필 사진을 아마 보시면 알겠지만 역대 컨퍼런스 중에서 가장 신비감이 뛰어난 프로필 사진이 아닐까 생각이 됩니다. 그래서 이 프로필 사진을 보면 대가의 자유로움이 느껴져서 저도 앞으로 프로필 사진을 어떻게 변경할까 하는 데 대한 영감을 받았습니다. 다시 한번 깊은 감사의 말씀을 드립니다. 마지막으로 개인적으로 I'm sincerely appreciate for your participation.
네, 다시 한번 참석을 해주셔서 감사드립니다. 머지않은 시점에
버클리 알럼나이.
네, 제가 또 버클리의 동문이기 때문에 네, 다시 한번 대면으로 판사님 만나 뵈시기 바랍니다.
하는데 제가 특정 팀을 응원한 건 아닙니다. 예, 다음으로 그러면 터키의 질리아 인제 판사님.
Now moving on, we will listen to the presentation of Judge Zilya Ince from Turkey.
인제 판사님 제 말씀 잘 들리십니까?
Judge Ince, can you hear me?
예. 바쁜 업무 중에도 이렇게
So despite your busy schedules, thank you for joining us as a panelist today.
가까운 시기에 한국에서 직접
I hope I will be able to meet you in Korea in person in the near future. So among the topics for the first session, please focus on the most important one, and please go for 10 minutes.
Okay, can you hear me?
예. Yes.
Yes, we can hear you well.
Thank you. Hello, everyone, and greetings from Turkey. I'm so happy and honored to be in such a distinguished conference. Thank you very much for inviting me, and thank you for the cooperation. Okay, I will directly start with my presentation. First of all, for the statutory amendments, I'm going to talk about the coming into force of the new IP code, which came into force in 2017. The IP code abolished previous IP-related decree laws, 4 decree laws, and entered into force on 10 January 2017. As it's known, Turkey has been a candidate country for the EU for a long time. After having the candidate country status, Turkey conducted official negotiations with the EU in order to become a member of the customs union. And within this framework, Turkey had to adopt its national IP law in accordance with the EU legislation. In order to fulfill this liability, in 1995, Turkey quickly implemented decree laws relating IP rights, such as patents, trademarks, industrial designs, and geographical indications. The legislator at that time preferred decree laws because fewer procedures were required, and it was fast and easy, actually, to put into force, and they had the power of law as well. even though they should have been transformed into laws as soon as possible, they remained in force until the entry into force of the IP code. And I'm going to talk about some essential changes in the IP code regarding trademarks, designs, patents, and international exhaustion principle, which was accepted. For trademarks, new types of trademarks were accepted. When the IP code came into force, EU trademark directive was in force, and the definition of the trademark transformed from the directive. The obligation of showing by drawing has been abolished. As soon as the signs are capable of distinguishing the goods and services absolutely and accurately, any sign like words including personal names, figures, colors, letters, numbers, sounds, shapes of goods or packaging could be a trademark. And another change is coexistence principle, notary letter. In the light of the old legislation, decree law, let's say, both the Turkish Patent and Trademark Office and the court accepted the unity principle of trademarks as a public order. Actually, if something is a public order in Turkish domestic legislation, judges per se take into account the issue during the whole case without any time limitation, and the parties are able to take the subject to the court as well. Although the registration of the same or very similar trademark in the name of different parts sometimes appear as a need, because of the unity principle, the system did not allow this. So after this drastic change, coexistence principle and notary letter, the trademark application may not be refused on the grounds of the unity principle. The bad faith claim is regulated as a separate opposition and invalidation ground for the trademarks. And another change is, if a trademark is not used, it will become non-functional. When a party applies for registration of the trademark to the office, when I say office, I mean Turkish Patent and Trademark Office. An earlier trademark owner was able to oppose it, but if the mark is not used in the registered class, the office is able to reject the registration demand. Okay, and also the office is authorized to revocate a trademark, which is called administrative revocation. Before the IP code, only the courts had the authority to revocate or invalidate a registered trademark, but after the code, also the office is authorized for this. But entering into force of this provision is postponed for 7 years, and it will come into force in 2024 because it's a very drastic change. And when it comes to designs, unregistered designs were not protected before the code. After the code, both registered and unregistered designs are protected. And for designs, novelty examination is foreseen for the registration. When it comes to patents, one of the most important improvements is post-grant opposition system. We did not have post-grant opposition system in the decree law period, but now we have. And one of the most important development is the IP code abolished all criminal sanctions in case of patent infringement. Now we have criminal sanctions for trademarks and copyright issues on the code. And there is no more patent granting without going through an examination process. This will lead to stronger patents in Turkey. And compulsory license situations are extended. In patent decree law, there were 3 reasons for compulsory license. After the IP code, we have 3 more reasons, 3 more situations for the compulsory license. And the legislator preferred international exhaustion principle for all types of IP rights. And for the second subject, the case trends, I'm going to talk about them. I have 2 cases, the internet service provider's liability and the use of trademark for criticism on the internet environment. The first case is Turkish Court of Cassation case and paved its way to the Court of Cassation Grand Civil Chamber. I chose to present this case since it was solved in the Court of Cassation, Grand Chamber, as I said, and in the Internet service liabilities, in our domestic system, court system, we use notice and takedown system. In this case, the litigant was a trademark owner who is a famous perfume company, and the defendant was an online shopping website, which is very famous, like Amazon in Turkey, actually. The litigant claimed on the ground that the defendant exposed the goods, which were counterfeit perfumes, on their website, and demanded declaratory and removal of the infringement, termination of the selling activity on the website, destruction of goods, and moral damages. The regional court, which was Istanbul First Civil Court of Intellectual and Industrial Rights, ordered an interim injunction at the beginning, and as a final judgment against the defendant to remove infringing content from its website, but rebuffed the claim to grant damages. After 2 appeals to the 11th Civil Chamber, Turkish Court of Cassation 11th Civil Chamber, which is relevant for the commercial cases, and IP cases are commercial cases in Turkey. The Grand Chamber, after the 2 appeals from that chamber, then the case went to the Grand Chamber, and the Grand Chamber anonymously went on to conclude that upon receiving a petition claiming on the infringement, case petition, let's say, the defendant became aware of the civil wrongdoing and hence had to be required to pay damages. And the second case is the use of trademark criticism on the internet environment. This was a constitutional court case, and the defendant, the constitutional court ordered that, concluding that the decision, I just realized that I have only 1.5 minutes, and I will try to conclude. The constitutional court concluded that the decision of the first instance court was proportionate and the intervention was in accordance with the requirement of the democratic social order, and stated that it was clear there was no violation of the applicant's right in terms of freedom of expression. And for the last topic, the hotly debated thing for the IP-related issues is mandatory mediation. After entering into force of the law in 2019, civil mediation in Turkey has become mandatory for certain IP cases, actually commercial cases, and as per commercial code, Turkish commercial code, IP cases are related commercial cases. According to the law, mandatory civil mediation where financial remedies, namely an award of payment of a sum of money as a performance of damages, are sought. In this sense, the claim in question must be a monetary nature. Thus, any claimant who intends to commence a formal action with a commercial pecuniary claim is first required to undergo mandatory mediation. However, an implementation problem occurs when monetary and non-monetary claims are raised together in IP cases, because the code introducing mandatory mediation does not provide a specific rule for disputes combining both monetary and non-monetary claims. So the Turkish courts had 3 options: passing through mandatory mediation and entering into force into the merits of the case for all claims, dismissing all claims based on procedural issues, and separating claims based on mandatory mediation requirement. Turkish courts preferred the last option for a long time, but in 2020, Turkish Court of Cassation 11th Chamber gave a different decision and said that if a pecuniary and non-pecuniary claims are together brought to the courts, then it's not the mandatory mediation is not useful. So it can be seen in front of the courts, before the courts. So it's a very hot debate. It's a very hot issue debated in Turkey. And this is the end of my presentation. Thank you very much for listening.
예, 인재 판사님 대단히 감사합니다.
Yes, Judge Inse, thank you very much for your comments. You sent us a very detailed response, and 10 minutes was a very short time for you to speak.
Yes, unfortunately, sorry.
예, 개인적으로는 상표 사용에서
Well, personally,
공존의
the coexistence principle and the administrative revocation right and protection of unregistered design were all very
제한을 높일 수 있는 많은
insightful and new inputs for me. Through your input, I hope that cooperation between the Korean and Turkish IP practitioners will become more active.
I'm afraid to say correctly thank you in Turkish, but I try. Teşekkür ederim. Again, teşekkür ederim. 자, 그럼 다음으로 인도의
So we'll move on to the Indian speaker. Judge Singh, we'll pass on the floor to you.
싱 부장 판사님
Judge
반갑습니다.
Singh, greetings.
예, 바쁜 일정 중에서도
morning.
예,
Can you hear me?
예, 바쁜 일정 중에서도 이렇게
Yes, thank you very much for taking part in today's event as a panelist despite your busy schedule.
제1 세션의 주제 중
So among the topics for session 1, in your view, can you speak on the most pertinent issues for about 10 minutes?
Yes, please.
네, 알겠습니다.
Okay. Very good morning to all of you.
여러분, 안녕하십니까?
Vogel,
교수님, 인세 판사님, 다시 한번 이렇게 뵙게 되어서 기쁘게 생각합니다.
Yes. In the first topic which I would be speaking about is the recent trends in IP in India. But before I do that, I would like to extend my gratitude to the Patent Court in Korea for inviting me today. I have been to Korea only twice, maybe in the last decade or so. I'm sure it's changed a lot. And I look forward to visiting your patent court. I read about the patent court in Korea and the international division in your reference book, and I'm highly impressed to see how you would be doing foreign language litigations in Korea. That's a very unique and an innovative step which I haven't come across in any other jurisdiction. The issues that we face in India are not very different from what Professor Vogel and Judge Inze have already said. But let me introduce you to the entire IP ecosystem in India. Firstly, I want to say that we have statutes for almost all IPs in India, including the basic IP rights and for geographical indications, semiconductor integrated layouts, almost all the major IP rights, except for trade secrets. So there is a debate in the national IPR policy, which came out in 2016, as to whether we need to have a sui generis system or a statute for trade secrets. That debate is still on. We do not have a statute on trade secrets as of today. Apart from that, the most important development that has taken place extremely recently, as of February, as of 2021, is the abolition of the Intellectual Property Appellate Board. We had created an appellate board for dealing with appeals and original revocation and cancellations of patents and trademarks. This board has been abolished, and the jurisdiction has been vested back with the high courts in India. So this has proved to be a challenge in the last few months. And the Delhi High Court, where I sit where I'm one of the members, judges in the court, has taken two important steps to deal with this issue. The first and the foremost was the creation of the Intellectual Property Division in the Delhi High Court. And we've also started drafting the rules for this IP division, and hopefully in the next month or so, we should be notifying them because they are up for stakeholder comments as of today. Secondly, we also face the same challenges in respect of experts in patent litigations, as Professor Vogel was saying today. And so we have drafted specific rules for patent suits in the Delhi High Court. And these rules have also been put up for stakeholder comments and are likely to be notified maybe in the next couple of months maximum. These particular rules and both these sets of rules have given a lot of emphasis on the technical aspects of intellectual property matters. So we are going to be permitting claim construction briefs, infringement briefs, and invalidity briefs to be prepared and filed by parties along with their pleadings. And for the IP division, there are two sets of technical experts that we are planning to provide for. The first set of technical researchers would be like law researchers. The IP division would be having 2 researchers who are technically qualified, so that on a daily basis, the judge can interact with them and get inputs on very basic technical matters. We also would be having a panel of scientific advisors in the court itself, maybe both from India and abroad, who can be used as court-appointed experts for patent litigations. And I think we not only need technical experts in patent matters, but recently we've realized that in one of the copyright-related issues, royalties were to be prescribed by the court, and the court considered that economists or accountants would also be required in order to analyze the accounts, etc., of the parties and fix royalties. So these 2 sets of rules, in my opinion, are going to be changing the manner in which intellectual property disputes would be dealt with in the Delhi High Court. And I have learned that even the Madras High Court has set up a committee as to how to deal with the matters which would be coming from the IPAB. So there would be a lot of change in the next couple of years, 2021 and 2022, in the various high courts in the country. So apart from these 2 major developments, I would also like to highlight that there is an amendment contemplated in the Competition Act of India, because there is a lot of conflict which is taking place between competition law and intellectual property law. So as on today, the statute provides for an exception in relation to anti-competitive agreements alone. But in respect of abuse of dominance, there is no exception for IP. And Section 4A is contemplated under the bill to be provided as an exception to anti-competitive conduct. So IP can be an exception to anti-abuse of dominance, and I don't know how this is going to work out, but this is one amendment which is under contemplation. The next 1 or 2 smaller developments are, there is a patent prosecution highway which has been signed with, it's a pilot program with Japan as of 2019. So we are hoping that with the experience of that, we would be able to have more and more agreements with various other countries. Now, moving on to the latest issues in intellectual property cases. If you see in the reference book, it is a detailed answer which has been given from me and my team at page 33 of the reference book. There are various issues that courts are facing currently, and the most important issue relates to online IP violations, both trademark and copyright violations, because as Judge Inze also just said, we are facing counterfeiting products on e-commerce marketplaces, etc., and piracy of various television channels and sporting events on the internet. So the courts have become very, very strict in this, and they've evolved the concept of dynamic injunction. So it is not sufficient, especially in respect of rogue websites which have predominantly, infringing content. The court has said it is not sufficient to simply pull down the URL, but also pull down the entire website. And since mirror websites can come up very quickly, you can have copied websites immediately when one website is pulled down. So the court has come out with the new concept of dynamic injunction, which can be granted by Indian courts. One of the major challenges we are facing in patent litigation is jurisdictional conflicts. There was a litigation where an infringement suit was filed in the Delhi High Court against a defendant, which was a Chinese company. The Chinese company then filed a suit for declaration and injunction in the Wuhan District Court in China, where they obtained an injunction that the American company cannot proceed with the infringement action in the Delhi High Court. So this is a major conflict of jurisdiction issue which we faced. The High Court has taken a view recently and has held that patent rights being territorial and infringement action cannot be stopped in this manner. So an anti-suit injunction has been granted by the Delhi High Court very recently. The third issue I would like to highlight is about global injunctions for infringing content. Google raised a defense in one of the cases that the Indian court cannot grant a global injunction. I'm sure this situation is similar to the equistic issue which Google has faced in the US and in Canada. But the High Court has taken a view that if the content is uploaded from India, then an Indian court can grant a global injunction. In the area of pharmaceuticals, since I have 1 minute to go, in the area of pharmaceuticals, the biggest issues we are facing are in respect of Marcus formula claims. There are issues about coverage and disclosure. There is a recent trend of decisions which have come out in relation to AstraZeneca patent. This is commencing the discussion had started in the Novartis decision of the Supreme Court as to whether the coverage of a patent can be higher or larger than the enabling disclosure in the patent claim. So the courts are taking different views in different cases depending on the facts. And I do see that there will be a lot of debate in these matters going forward. So I would like to end by saying that e-commerce platforms are providing a huge challenge for IP. There are recent intermediary guidelines which have been issued by the Indian government in 2021, making it much more stricter. The compliance by intermediaries has to be much stricter than it used to be before. So we are having an evolving ecosystem, and we are in for interesting times in India. And I look forward to the discussions today. Thank you. Thank you very much.
예, 신구장 판사님 감사합니다.
Thank you, Judge Xing.
방대한 내용을 소개해 주셔서
The vast amount of information has been provided to us in India. The repeal of the IPAB and the creation of an international division in the Delhi High Court, and also the IP examination highway program with Japan, and also a few cases related to jurisdiction has been explained to us. So Judge Xing, I think, represent the very history of the IP area in India. So she is a widely respected legal expert. So I would look forward to a time to meet with you personally.
See you in Korea soon. 예, 다음으로 마크 슈바이츠 연방법원장님의 발표를 사전 준비된.
Next, we will watch a pre-recorded presentation of Mark Spicer, the president of Swiss Federal Patent Court.
It's a great honor to have been invited to the International IP Court Conference, even if only virtually, and I do hope that I will one day be able to all see you in person. As you can probably guess from the background, I'm at home. My office is not equipped for video conferencing. Our courtrooms are fully equipped for video conferencing, but I didn't want to sit alone in a very large courtroom for this session. So this session one on the trends in IP in Switzerland. Well, the trademark and patent law has not been changed recently. What has been changed recently is the Copyright Act. Here, there was a number of changes. One of the more important ones was that, according to a Supreme Court decision of the Swiss Supreme Court, right holders were not allowed to collect the Internet Protocol addresses of people sharing illegal copies of copyrighted works, mostly movies, of course. This was, according to the Supreme Court, a violation of their data privacy. And this led to a lot of criticism by the associations of the right holders and a lot of pressure, notably by the United States, where, as we all know, a lot of the major movie companies are headquartered. And now the law has been changed. It came into force, well, actually last year, April 2020. And now the right holders can collect Internet Protocol addresses and then forward them to the relevant authorities who can find out and identify the people behind the Internet Protocol addresses. There were other changes, stay down provision for hosting providers. There was always a takedown decision provision. Now they have to make sure that illegal content not only is taken down, but is not re-uploaded. So this is in trend with most major jurisdictions. I think it's nothing unusual. A major revision of the Patent Act is currently pending. It is still being subject to parliamentary debate, so it is not clear exactly where it is going. I will make a few remarks about it later on. Now, major trends of IP cases in my country. I should add, probably for the benefit of the listeners, that I am the president of the Swiss Federal Patent Court, and we are competent only for patent cases and supplementary protection certificates. Both infringement and validity, unlike, for example, the German Federal Patent Court, but we do not handle copyright or trademark cases. So I am, unfortunately, probably not the right person to inform you about any trends in copyright and trademark litigation. Now, in patent litigation, I should also say that Switzerland is a relatively small country. We have about 8.5 million, population of about 8.5 million, which is actually less than Seoul. So the city of Seoul has more people than the whole of Switzerland. So the number of cases being litigated, and especially the number of cases that actually goes to trial and goes to judgment, is relatively small. So it is difficult to say there is an overall trend. What we do see, which I think is interesting in the last couple of years, is we see fewer cases of classical pharmaceutical disputes between originator companies and generic companies. This used to be a mainstay of patent litigation in Switzerland. It was probably half of all the cases were originator against generic entry. Now, this is much less. We this year had a few cases, but it's much less than in the past. And therefore, actually the overall number of cases is slightly declined, and there is a shift more towards medical technology and to some extent information and computer technology. Although I should say that, unfortunately, in my opinion, but it's a fact that Switzerland is not a leading nation in internet information and computer technology. We are strong in pharmaceuticals, as you probably know, and there is little litigation in the field of ICT industry, simply because it's not an important field in Switzerland. There is the occasional case, but it's certainly not something where Switzerland is leading the charge internationally. Now, current legal issues hotly debated in IP. Before I mention the revision of the Patent Act, which I think is, it's very peculiar for Switzerland. I'm not sure how much of interest it is to an international audience. One thing that we see recently in patent cases is that patents are increasingly being found invalid for modifications during the prosecution. So this is a trend that comes from the European Patent Office, which is increasingly strict about amendments to both the claims, most importantly, but even the specification of the patent may only be amended in a very limited way during prosecution. And if you run afoul of these provisions, it leads to the invalidity of the patent. And recently, about half of the patents that we found invalid were found invalid due to added subject matter, I think is the term that the Americans use for this. This is a recent trend. I'm personally not sure that this is a happy trend. It becomes very formalistic, but that's the way things are. Increasingly, this is being litigated. Obviously, novelty and inventive step are still important issues, but the added subject matter has become increasingly important over the last couple of years. You have to be very, very careful about amendments to your patents during prosecution. Now, as I said, in Switzerland, I would say most important issue is the revision of the Patent Act. There has been a first draft, which has been widely criticized, to be honest. The background is that Switzerland currently does not have fully examined patents. National patents, I should say, to be precise. Swiss national patents are not examined for novelty and inventive step. So you could theoretically actually file a patent for the wheel in Switzerland. And if you formally do it correctly, you have specifications, you have a claim, and it's done formally okay, you would get a patent for a wheel, because the patent office cannot reject an application for lack of novelty or lack of inventive step. Of course, if you did get a patent for a wheel, the patent could be invalidated by the competent court. So my court, the Federal Patent Court, could find it invalid. So if you would try to enforce it, you would not come very far. It would not be enforceable. However, you would get it on paper, you would get it. Now, this has been criticized, and there has been a suggestion that Swiss patents should also be fully examined also for novelty and inventive step. This was a suggestion in the first draft, but for a number of reasons, the industry and also professional associations were not happy with this draft. And as it currently stands, the idea is to keep the not fully examined national patents, so not examined for novelty and inventive step, and have in addition a fully examined national patent. So you would keep the current non-fully examined patent plus have an additional fully examined patent. Now, personally, I'm not sure how big of a demand there is for this fully examined national patent if you can also get a national patent with the same duration and the same rights without a full examination. If you want a fully examined patent in Switzerland, the easy route and the way that everybody does is you get a European patent and then validate it in Switzerland. So over 90% of patents in force in Switzerland are European patents. So they are granted by the European Patent Office in Munich and The Hague. And then they are validated in Switzerland and they have the same effect as a Swiss patent. They can also be found invalid for the same reasons and before the same court. So if you want a fully examined patent, you go the European route and you get a fully examined patent. And if you don't want that for a number of reasons, then you can get a national patent which is not fully examined. Now, this proposed revision will add another option, which is the option of a fully examined national patent, but it will keep the current system of a not fully examined patent. So that's the way things stand. I'm not sure this is something other countries would want to emulate. It is, I think, based on historic reasons. The main reason being that the number of national patent applications is relatively small, and it is difficult for the Swiss Patent Office to have examiners which are qualified in all the different technical fields. So this is historically the reason why they did not do a full examination. Again, if you want that, you can go to the European Patent Office. Now, I'm not sure why this has now changed and why now suddenly they should be able to do a full examination. So as you can hear, I have my doubts, but this is how things are standing. So I think my time is up. I don't want to hold you up. I hope everybody is having a great conference, and as I said, I hope to see you in person one day. Bye-bye, and I see you in session 5.
예, 감사합니다.
Thank you very much, President Schweitzer. Thank you for explaining the recent trends in IP law in Switzerland. I enjoyed the view of your personal study. I noticed the interesting designs, and I really appreciate your honest and frank remarks about Swiss and international IP trends. Well, we are a bit late on time and we're going longer than expected, but still we have rich content that has been prepared, so we will proceed with the session. We made go 10 minutes over the allotted time, and now we will hear from Judge Chung-Taek Soo from Korea Patent Court. So all of the honorable IP experts from around the world, hello, I am Judge Chung-Taek Soo from Korea's Patent Court. I'm in a bit of a dilemma, actually. I want to make sure to secure your lunch break. So as much as I want to share all the content that I have prepared, I want to honor your lunch break, so I will make my comment very short. So with all the honorable panelists from around the world, I was very impressed by the diversity. As the keynote speaker, Professor Chung, mentioned, we must understand the diverse systems of different countries and show mutual respect. So there were many interesting points in Switzerland. There is no full examination on novelty and inventive step for domestic filings, and you showed a very rather questionable stance on the amendment. But the non-examination was abolished in Turkey, so that was a very striking contrast. In the US, on the other hand, PTAB is being strengthened while the IPAB was abolished in India. So we are seeing very contrasting trends among different countries. Also, as long as there is the consent through the notary, then the coexistence principle is now being introduced in Turkey. That was a very new input for me. Well, I say this because Chief Presiding Judge Seung-yeol wanted me to give a brief comparison between the system of other countries versus that of Korea. So that is why I'm making such comments right now. I gave a quick summary, but I just want to add one more comment. Well, this was from India. Judge Singh, she mentioned the Novartis case. As you are aware, well, you might not understand the full content of the case, but it was about the genus and the species substance, and if the species of substance have significant effect compared to genus, then it can be registered. So in India, there is no distinction between the novelty and inventive step, and the requirements are resembling that of the US. And what is more important is that effect is of the utmost importance. And Korea also had a Supreme Court decision on Apisaban. I can't go into too much detail, but we are going on a different path than India. And the US, Japan, EU, I think we are joining that similar path. So such roads or paths for the future is being shaped by the circumstances of each country. I think that should be acknowledged. So how is the legal ecosystem and environment of Korea different from that of the other countries, and how can we reach a consensus? I think these are issues that merit much contemplation and discussion. I believe that in IP law, I don't think there is one golden path. Even philosophically, changes bring innovation. Well, we should avoid just ruling out what is different from us, but we should respect such differences, and that was the insight that I got from the first session of IIPCC, and it was a great honor for me to join as a panelist for this session. I would like to extend my gratitude to every participant, and thank you.
예,
Judge Jung, thank you very much. Because of the time constraint, I think he shortened his comments. So there is a written response that has been provided by Judge Jung in the reference book regarding the three proposals that he makes. He also includes many of the pertinent court decisions in Korea. And looking through his written response, I was able myself also to organize my thoughts about the topics at hand. So I would like to suggest to all of our panelists and participants to please look through this written answer by Judge Jung. I myself benefited greatly by reading his answer. So let me conclude today's session. I would like to thank all of you who have prepared for and participated in today's session, especially those who have participated from overseas via online. I would really like to see you face to face in the near future in Korea. So early this year, when the fatigue over the COVID-19 pandemic was building up, the Chief Judge, Seung-Young Lee of the Patent Court of Korea, presented the slogan for this year for the Patent Court. Let me introduce that slogan to you. In the New Year's address, Chief Judge Lee talked about the resilience, immunity, capability, so strengthening all three factors. He said that these were the key qualities that legal experts should have in this age of pandemic. So, as Chief Presiding Judge, I myself added harmony to the three qualities, and I crafted the slogan for 2021 for Patent Court. The word rich, however, we didn't have enough time to commercially prepare this as a official slogan. But I would like to take this opportunity in today's conference, in wrapping up the session one. I would like to shout out this slogan to all of you. Especially, I really would like to send this message to the panelists. I wish all of you to be rich. And there was a quiz at the beginning of this session. Do you know why we have selected the 5 countries that we did as panelists? I don't think any of you would have been able to find an answer to this. It was a very difficult question. So we have 5 countries participating as panelists in session 1, and for the 5 countries, the title of this session was Recent Trends in Global IP Litigations. So litigation, in the litigation, we have 5 countries participating. And what is the corresponding word? Shoot. S, Swiss, S, U for United States, and I for India, T for Turkey, and South Korea S. So suits. Yes, that was, a joke. So these 5 countries are representing suits. I really would like to express my appreciation for your hard work and participation. I really look forward to meeting you in person in the near future in Korea. So with this, I would like to wrap up session 1. Thank you very much for your attention.
It was a very fruitful and interesting session. Thank you, Chief Presiding Judge Seo Seung-yeol and Judge Jung Taek-soo from the Patent Court.